Elvis Presley died without a living trust, and his family lost over 70% of his estate to taxes and court fees. Prince didn't have one either, and his estate stayed locked in court for over 6 years. If you own a home and don't have a living trust, your family could face the same nightmare. By the way, if we haven't met yet, my name is Aileen Gutierrez. I'm the operations manager and financial strategist here at We're Life Group. Our mission is to help families like yours protect what they've built and avoid unnecessary financial stress. And through our sister companies, We're Real Estate, Momentum Mortgage, and Exclusive Escrow, we're able to support our clients through every single stage, from buying a home to financing it to protecting it long-term with proper planning. Now here's where most people get caught off guard. If your home isn't protected by a living trust, your family could be facing a really difficult situation at the worst possible time. A lot of people believe that having a will is enough, but the truth is a will still goes through probate. It doesn't avoid court. In fact, it's often the very thing that sends your family there. And once that will is filed with the court, it becomes public record. That means anyone from distant relatives to strangers can see what you owned and who got what. There is no privacy. If there's no will at all, it gets even more complicated. Now the court decides who gets what based on your state's intestate succession laws, and your wishes may be completely ignored. In California, the only way to avoid probate without a trust is if your estate is worth less than $184,500. That includes any real estate, bank accounts, investments, basically everything that you own of value. But realistically, what property in California is worth less than that, right? If your home isn't in a trust, your loved ones won't be able to sell it, refinance it, or even access it until a judge gives legal permission. And that can take months, during a time when your family needs clarity and peace. Now imagine this, your parents pass away and the home they worked their entire lives to pay off is supposed to be passed on to you. But instead, you walk into a legal nightmare. The court tells you probate will cost around $30,000 and they want it up front, not after, not later, up front. Meanwhile, the average American barely has $1,000 in savings. So now you're scrambling, borrowing money, or putting legal fees on a credit card just to claim what was already yours. And here's the worst part. Even though it's your home, you can't move in. You're not the legal owner. Your home is frozen in the court system. According to Nolo, a trusted legal resource, property in probate can't be transferred or occupied until a judge gives formal approval. I've seen cases where the house sat vacant for so long it became a target for squatters, and the locks had to be changed and windows boarded up just to protect it. In some areas, law enforcement steps in to secure the property until the estate is sorted out. The home that was supposed to be a blessing turns into a burden, draining your family emotionally and financially while it sits there empty, locked, and tied up in court. And after all that stress, you realize you can't afford the legal fees. You can't afford the mortgage. You can't even afford the fight. So the home is sold to the highest bidder at auction. Now you're standing on a sidewalk, watching the home that you grew up in, filled with childhood memories, your parents' hard work, their legacy being handed off to a complete stranger just because they had the capital and you didn't. What your family really needs is a plan that takes the court completely out of the picture. Something that keeps things simple, private, and protected so that during one of the hardest times in their lives, they're not dealing with paperwork, court dates, or legal stress. A plan that says, here's exactly what happens with the home, the accounts, and everything else. There's no confusion and no conflict. That's what proper estate planning should do. It should give your loved ones peace of mind, not more pain. That's exactly what a living trust does. It's a simple but powerful legal document that allows you to decide in advance what happens to your home, your finances, and to your legacy. It keeps everything out of court, out of the public eye, and exactly how you wanted it handled. We help families create complete living trust packages that include your declaration of trust, pour-over will, durable power of attorney, advanced healthcare directive, and certification of trust, all personalized to your family's needs and fully certified by licensed professionals. Now, if you have a mortgage, you may have heard that putting your home into a trust could cause your lender to call the loan due. That's called the due on sale clause. And yes, some lenders will try to scare you with that. Sometimes it's because they don't have a background in estate planning and therefore don't fully understand or know the law themselves. Other times they're simply trying to protect their own interests instead of protecting their clients. Either way, here's what you need to know. Under the federal Garnt St. Germain Depository Institutions Act of 1982, you are fully protected when transferring your home into a revocable living trust as long as it is done correctly. Title 12 U.S. Code Section 1701J 3D8 clearly states that a lender may not exercise its option pursuant to a due on sale clause upon a transfer into an inter vivos trust in which the borrower is and remains a beneficiary and which does not relate to a transfer of rights of occupancy in the property. So, in plain English, if you're placing your home into a revocable living trust for estate planning purposes and you're not changing occupancy rights to anyone else, and lastly, you are the one benefiting from it, they cannot call the note due. Period. Federal law overrides anything they put in fine print. Your mortgage stays intact, your protection is secure, your peace of mind is guaranteed. So, what's the alternative? You listen to the lender, you leave the home out of the trust, and now when you pass, it goes straight into probate. Your family ends up in court, they wait months, they pay thousands of dollars, and the home that you worked your whole life gets tangled up in a legal mess, all because you were misinformed. Now remember, this is not just paperwork. This is how you protect your family, your home, and your legacy. When you set up a living trust, everything becomes easier for the people you care about most. There's no court. Your family won't have to fight through months or years of probate. There's no legal delays. Your home, bank accounts, and personal items are transferred smoothly to the people that you choose, so there is no waiting. There's also no unnecessary fees. You'll avoid thousands of dollars in court and attorney costs. Your privacy is protected. Everything stays out of public record and stays in your family's hands. And lastly, peace of mind. You'll sleep better knowing that your family won't be left in a legal mess and there won't be any conflicts. But a complete estate plan is more than just a living trust. Remember, we're also including your durable power of attorney for finances. If you become incapacitated from an accident or illness or even cognitive decline, someone still needs to handle your finances, pay your bills, or access your accounts, or manage property on your behalf. Without a power of attorney, your family will have to go to court just to act on your behalf, even for simple things like paying your mortgage or accessing your bank account. You also have your advanced healthcare directive. Now, this document gives someone you trust the legal authority to make medical decisions for you if you were to be unable to speak. Now, this lets you clearly state your wishes about life support, resuscitation, and end-of-life care. Without it, your family could be left arguing in a hospital room, uncertain about what you would have wanted. Now imagine that you were in a car accident. You're unconscious in the hospital and your family is scared and overwhelmed. But now they can't access your bank account to cover emergency bills. They can't manage your mortgage or talk to your insurance company. And doctors are turning to your next of kin who may not agree because there's no healthcare directive in place. That's why these documents matter. A living trust protects your assets after your death, but a healthcare directive and power of attorney protect you and your loved ones while you're still alive. This isn't just about documents, it's about protecting your legacy, honoring your wishes, and giving your family the freedom to grieve and heal without added stress or conflict. If you've made it this far, it probably means you care deeply about protecting your family, not just financially, but emotionally too. A living trust, a power of attorney, a healthcare directive, they're not just documents, they're acts of love. They're your voice, your values, and your plan, even when you're not able to speak for yourself. We're here to guide you through it. We'll help you understand your options, explain every step clearly, and make sure your estate plan fits your unique needs, not some one-size-fits-all template. So click on the link below to schedule a free consultation. There's no pressure and there's no cost to talk, just a conversation that could spare your family months of confusion, stress, and thousands of unnecessary costs. You worked hard for what you have. Let's make sure that we protect it and the people you love the right way. Now, we understand that choosing who to trust with your estate plan is a big decision, and that's why we work with some of the most respected professionals in the industry. We have George Hernandez, an estate planner with over 30 years of experience, trusted by hundreds of families across the United States. We also work with AmeriEstate Legal, a respected legal firm with over 10 estate planning attorneys, experienced in handling even the most complex family situations. And Estate Guru, a modern estate planning platform where every living trust is reviewed and certified by a licensed attorney, giving you legal confidence without overwhelming complexity. Whether you decide to sit down with an expert or handle everything online with professional guidance, we'll help you choose the option that fits your lifestyle and comfort level. Now again, this isn't about selling you documents. It's about connecting you with real legal protection backed by experience so that your family isn't left vulnerable when it matters most.